Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. There has been a document drop of new documents in Idaho versus Kohberger, two of which relate to the juror questionnaires in anticipation of the trial of this matter, which is currently scheduled to commence summer of 2025. The first new document that appears on the public docket is defendant's motion to seal notice of filing defendant's objections to the juror questionnaire. It states, comes now Brian C. Kohberger, by and through his attorneys of record, and hereby moves the court for an order to seal the notice of filing defendant's objections to the juror questionnaire. This motion is made pursuant to ICAR 32I and IC, Section 74124, subsection 1B and C, because they are either previously already sealed or are redacted. Dated this 21st day of May, 2025, Ann C. Taylor. A couple of points, ladies and gentlemen, regarding this filing. First, what the defense is really doing here. Hereby move the court for an order. That is what a motion is. A motion is a request for the court to enter an order providing whatever relief that the party is seeking. Here, what the defense wants is for the court to seal the objections to the juror questionnaire that the defense has posed, which is under seal temporarily. What the defense wants is for the court to seal it so that it will not go on to the public docket. Secondly, what has been raised here is a court rule, 32I, and a statute of the state of Idaho. That is what 74124 is. But what the defense is not raising is that the court itself ordered back on October 9th, 2024, that is the date of the filing of the pretrial and trial order that Judge Stephen J. Hippler has rendered, that anything relative to juror questionnaires was to be filed under seal. You'll find that information on unnumbered page 3 of that court order. Unclear why the defense would not raise that also as good cause, just by looking at the face of what that order says. And third, when the defense states that prior juror questionnaires are either previously sealed or redacted, they are not redacted. Everything is sealed. If you look at the docket, you will see that both sides asked for their proposed jury questionnaires to be filed under seal, and Judge Hippler granted that. So everything related to jury questionnaires are sealed. Nothing is on the docket in a redacted format. Now, following the entry of that motion, the court on the 22nd of May rendered an order sealing the notice of filing defendant's objections to the juror questionnaire. So we see here that the remedy that the defense was asking was indeed granted by Judge Hippler. It says here, the court having before it the motion to seal the notice of filing defendant's objections to juror questionnaire and good cause appearing, now therefore it is hereby ordered the notice of filing defendant's objection to the juror questionnaire shall be filed under seal per ICAR 32I and IC section 74124(1)B and C. So ordered May 22nd, 2025. Signed, Judge Stephen J. Hippler as district judge in this case. Once again, there is no mention here that the court had ordered the parties to file everything relative to juror questionnaires under seal, and presumably the good cause appearing was the fact that the prior juror questionnaires were filed either completely under seal, which they were, or redacted, which is what the defense had stated. We provide our opinions here based on the face of the filings. No legal advice is intended or given, and everything here is opinion. This will now conclude this episode of the Indie Zone. Thanks for joining us today.